have spent, as I said upstairs, months combing through all of the evidence that we could collect from everybody that's been involved in this investigation to try to figure out as best we could what happened. And one of the things you'll find in the report we filed today is as close as we could come to a second by second, sometimes portions of a second, timeline of what happened during the confrontation between Mr. Anderson and Joseph Mensah. We concluded that there's no doubt that Mensah pointed his gun and intentionally shot Mr. Anderson and caused his death. So there's no question that this would be at least second-degree murder if we could also prove that it was not self-defense. And our burden is to disprove self-defense beyond a reasonable doubt, unanimously among all the jurors. And so as the months went by, we focused more and more attention on this issue of self-defense. We looked at blood spatter evidence that was presented, and we found that it was unreliable. What was presented was blood spatter was not on the passenger seat or on the floor beneath it, so therefore he couldn't have been leaning at the time he was shot. Well, we found actually blood spatter on the window behind the passenger seat. So obviously there was blood spatter, it was just in a different direction. So we concluded that the blood spatter evidence just was not reliable. As Attorney Motley mentioned in the courtroom, there was also Jay himself, the wounds. But nobody could tell which wound happened first. And the medical examiner told us that you can't tell the posture of the body at the moment it was shot from the location of the wounds without knowing a lot more information that nobody had. So we focused increasingly on the video that came from his Mensah's dash camera. This is the two slides that are in our report. The top slide shows you Jay Anderson's position in the car 1/3 of a second. I'm sorry, 2 seconds before he was shot. So you can see his hands are up in the air and he appears to be compliant. The bottom picture is exactly 2 seconds later. And you can see that he is leaning towards the seat where his gun is located. You can see his right hand has dropped down towards that seat out of view. Slightly less than 3/10 of a second later, Mensah began firing. So we know that the position that Jay was in when he was first shot was he was leaning towards the seat where his gun was located and his hand had dropped down towards that seat. The question then became, was that enough to convince a reasonable person that they needed to save themselves by shooting the person that was trying to shoot them first? That was essentially the self-defense question. Tim and I looked at this. I've looked at this 50 to 100 times. I've lost count. I've shown it to over 30 people, including civil lawyers, criminal lawyers, retired judges, and current judges who are not involved in the case. Tim did the same thing up in La Crosse. And then we convened what I call a focus group of diverse, jury-eligible Milwaukee County residents. And we taught them the law and self-defense. We showed them all this video evidence and asked for their opinions and listened to what they had to say. It was overwhelming among the whole collection of people that saw all of this, that if they had been in Mensah's position, or if any reasonable person had been in Mensah's position, they would have been afraid that they were about to be shot, and they would have felt that they needed to fire first. We have to prove the opposite of that beyond a reasonable doubt, and among 100% of a jury of 12. And ultimately, we had to heed the Wisconsin Supreme Court's advice or admonition. This says if you honestly don't believe you can prove your case beyond a reasonable doubt, whether it's a cop or a citizen, you should not charge them with a crime. And that's where we ended up. We cannot prove it beyond a reasonable doubt, so we decided not to charge. Before I start taking your questions, and Tim starts taking your questions, the very last point in our report talks about Assembly Bill 112. I hope you all take the time to go read that bill. It was in the last legislature. It died halfway through because the legislature ended and it didn't get passed. It had bipartisan support, and it would adopt an expert panel like the National Transportation Safety Board that would look at all of these officer-involved shootings, whether the officer was shot or whether the officer shot somebody. They would look at all the factors that contributed to that bad outcome, and then would make recommendations about how things could be done in the future to reduce that risk. Airline safety is so much better than it was 40 years ago when planes were crashing because of wind shear and icing on the wings and ducks at the end of the runway and all sorts of things. If the legislature adopts AB 112, we may be in a different pattern that over time leads to fewer and fewer of these tragedies, because even if it's not a crime, it was tragic. Jay was asleep, and 5.5 minutes later he was dead. And that's a tragedy. We had to tell the family last night. It was hard. It's going to be hard for them for a long, long time. We feel terrible about what they've had to go through. But don't forget AB 112. It may be a key to getting out of this cycle where, because there's no prosecution, the cops think they did everything right. Because the civil action gets settled with damages and nobody admits doing anything wrong, the cops think they did everything right. There's no introspection. The AB 112 would hopefully change that.
Did you speak? Oh, I'm sorry.
You want to go ahead first?
Yeah. Do you have anything else?
Just a couple things about the law of self-defense and following up on the recommendations. In a lot of police shootings, the officer is attacked, responds with force, and kills a citizen. That officer is a victim, also potentially a suspect, and also a responding officer that's required to write a report in his employment. So you can see how it gets complicated. And when we start doing a criminal investigation or even a civil lawsuit, like Scott said, you can see how these interests become at cross purposes, and it's hard to just get answers because there are things hanging over people's heads. So something like AB 112 might help change that, to look at it more holistically and say, how can we improve this, instead of, is there a crime or isn't there? Because the criminal process, as we've seen, doesn't really give us a lot of avenues for change or for answers for the family. I want to explain a little bit more about the self-defense, because I know there'll be some questions about this issue of self-defense. We started this case looking at it as an intentional crime, like Scott said, and self-defense was obviously an issue. But then we also took into account what the judge found at the hearing, that there may also be reckless or negligent homicide charges. And that's based in large part on the assumption that what Officer Mensah did before the shooting was wrong, against policy or against training. As we looked at it, we found there are differences of opinion in that area. Whether you park in front of a car, behind it, not necessarily wrong. Approaching the passenger side, actually used quite often these days, especially by state patrol. Not turning on red and blue lights. Some officers said I wouldn't have done it either, others said I might have. And so we found ourselves not really being able to find a clear violation of policy, but certainly not the law. And in any event, we decided, even if Officer Mensah did everything wrong, and against training, against policy, none of that had to do with causation. That did not cause Jay's death. Whether he parked in front or behind, that encounter at the window probably would have gone the same way. Whether red and blue lights were on or off, again, the encounter at the window is kind of where this all starts. And so we decided that whether you're looking at intentional crimes, reckless or negligent, self-defense is still a defense. And when you look at self-defense, you look at it from the officer's position at the time, and would a reasonable jury find that he was in reasonable fear of death or great bodily harm? And his belief can be reasonable even if it's mistaken. So in other words, we heard questions about, well, what if Jay wasn't even reaching for a gun? Maybe he was reaching for a cell phone or reaching for his wallet or his ID. It doesn't really matter. We'll never know, because the question is, what did Officer Mensah view at the time? Could he have reasonably believed he was reaching for that gun? And I think most people answered yes, that the gun was right there. Even if he was mistaken about it, it still could be reasonable. And as Scott mentioned, I showed this video to many law enforcement officers, attorneys, friends of mine in the La Crosse area, and almost unanimously they said, you know, it's bad, but if I were that person, I would think he was going for a gun, and I probably would have reacted the same way. And then we did the mock jury to kind of see what Milwaukee County people would think. What would a Milwaukee County jury look at? And they were largely in agreement. And so when we had the incident on video, the alleged crime on video, some of those surrounding things become less important, because what the crime is, or alleged to be, is really those seconds when they're at the window and in the car and the shots are fired. And so that's why in the end we decided it was likely a situation where Officer Mensah reasonably feared for his own death or great bodily harm, or at least a reasonable jury would believe that he had a reasonable fear. Whether he should have done it or could have done other things are, again, questions that we can't answer, and maybe a different type of investigation could answer, but that wasn't really our role, and our role was to find out whether or not we could prove a criminal offense based on this specific incident, and what we found is we wouldn't be able to do that.
So would you call this shooting justified?
Yeah.
We try not to use the word justified. I don't like that word because it sounds as if it was the right thing to do morally, and that's a different question. I could say legally, I don't see it's a criminal act. I don't think I can prove a crime beyond reasonable doubt. But saying that it was the right thing to do or should be done again if the same situation happened is a different question. And I don't think anyone should feel good about this. Police shouldn't feel like this is the way you should do things, or this is the outcome we want. So that's why I try to avoid that word justified, because it has, to me, a connotation that it was the appropriate thing to do or the right thing to do. And that's a different question for me than, is it a crime?
During your investigation, did you ever speak with Joseph Mensah or interview him about what happened at that window?
No, we tried, but his attorneys wouldn't let him talk to us. We asked them written questions, and we got written answers. In our opinion, in my opinion anyway, those written answers were like a lawyer's answers to interrogatories, so it fused in his expert witnesses, views and everything. It was entirely exculpatory. And as you'll see in our report, we did not rely on anything Mensah said that was not corroborated either by the dash camera or by the audio tape between the dispatcher and Mensah. Now we present in our report the things that Mensah said happened at the window, but we cautioned the reader that we didn't rely on what he said about that because we couldn't corroborate it.
I would also echo that that's one of the things I was talking about. When we've got his investigation going, he has a right to remain silent. He doesn't have to talk to us. And in fact, nobody had to talk to us. We don't have the ability to subpoena people or force them to testify under oath or force them to talk. And that's another reason why a criminal investigation closes some doors that otherwise might be beneficial.
Yes.
Does he say in those written statements, I acted in self-defense? Does he say it specifically?
Yeah, he said he thought he was going to shoot. I don't remember the exact words in his report. His lawyers have said that absolutely he would plead self-defense. There was no other defense. He intentionally shot Jay, and the only defense is that he had to have feared for his life. Otherwise, it's an open and shut crime.
And he writes that to you, I fear for my life?
Yes.
He also was interviewed originally by the Milwaukee Police Department when they did their investigation, and he was interviewed by them face-to-face. And we mentioned in a report that we prefer those be recorded, but it wasn't an interview with it was not recorded, but it wasn't an interview with the investigator. So we have that statement from the investigator saying what Joseph Mensah said, and in that he also said that he thought he was going to grab the gun and shoot him, and he had to act in self-defense.
And forgive me for asking this, but I'm curious because for self-defense, I know this isn't a trial, this is just the burden of probable cause, but for a self-defense case, don't you want to hear from the person that it happened to in their state of mind?
We'll let at trial, you would have to hear that. But again, you've got the report from the police who interviewed him. He made some comments that seemed to some other officers that were on squad camera. And then we have his attorney's statements to us. So our belief is at trial, we know what he would say based on the interview with the police and what his attorney told us.
And the other thing is, I mean, at trial, of course, we would cross-examine him.
Yeah.
We would try to make him out a liar. But at the end of the day, the dash camera doesn't lie. And that's why we decided that a jury is going to be most persuaded by the dash camera, that it is what it is. It shows what it shows. And whether or not you think Mensah's a liar or not a liar, the dash camera is showing what actually happened. And that is what informs whether or not a reasonable person in his position would have thought he had to shoot first to save himself. And,
But it wasn't turned on initially.
right, you're right.
It back timed.
Yes.
Do you think turning it on initially would it have changed anything? Do you think body cameras would have made a difference in this case?
I think if you had turned it on earlier, the audio goes on as soon as you turn it on. And so we would have probably captured some of the conversation back and forth. It's 23 feet away, and I'm not sure how sensitive the microphones are, but you might have caught some of that colloquy back and forth, which we all wanted to know about. Everybody wants to know what was going on between the two of them. There's about 45 seconds where he's interacting with Jay, and there's no dash camera on, and so you have to look at their conduct, and that's what you see here. But yeah, if he had turned on his dash, it wouldn't have changed the interaction, I don't think, but it would have changed what we know about it.
But your question is, would it have made a difference? And I guess we don't really know. Could it have? Maybe. But a body cam would have done two things. First of all, if they have body cams with any interaction with the public, it erases some of these questions that we have. And secondly, it would give us the viewpoint he had, instead of this is actually not even a straight-on view of a car, and so we're making a judgment based on what we see, but you can tell Officer Mensah would have seen something totally different. He had a different angle. So how he perceived it and how he saw it would have helped by the body cam. Would have made a difference? That's an answer we can't really know for sure.
It also probably would have picked up the conversation much better than a dash camera that's 20 feet away. Isaiah.
So you mentioned that a jury, now like the mock jury that you did, you mentioned that they were most of them agreed that Officer Mensah would reasonably be in fear that Jay was reaching for a gun. But the scene wasn't preserved by law enforcement officers after the fact, even before firefighters were allowed on the scene, before MPD came to take over the investigation per state law. So isn't that fact even in question of where the gun actually was?
First of all, we know he had a gun because Hakeem Fudge testified that he saw it in his pants, in the belt of his pants, just before they left and parted company at a gas station. Jay left and went to the park, so we know he had a gun.
And his DNA was on the gun.
And his DNA was on the gun. We also know that the first two officers to arrive on the scene, about 2 minutes and a few seconds later, Mills and Sawyers, parked their squads on either side of Mensah's squad. All of them had their dash cameras going, so you can hear Sawyers telling Mills to to remove the gun, and you can see Mills reaching into the front seat and pulling out the gun, and you have different views of it depending on which dash camera you're looking at. So there's no doubt in our mind that there was a gun sitting on the front seat, and that that was what Mensah thought Jay was reaching for.
Did Mills ever say why it took him a couple minutes or a couple moments to actually retrieve the gun? Was he more to that side of the car instead of just going right where it is, apparently in plain sight, and taking it out?
What he was doing in the beginning is they were trying to make sure that Jay wasn't still dangerous. Then he was walking around the car to make sure that the back seat was empty and didn't know what was in the back seat. And as he was walking around the back of the car, if I remember the video, Sawyers said, remove the gun, or you're going to remove the gun, or something like that.
So So basically, the answer is they were securing the scene. They said, making sure everybody was safe, making sure there's nobody else in the car, making sure that Jay was going to be taken out of the car. That was their answer. They were securing the scene. In that process, they then removed the gun.
Securing the scene, but is there preserving it though?
Yeah, it was a mistake. It was a mistake to move that gun before it was photographed, because you want to know exactly where the gun was and what the position of it was.
And another argument for body cams, because if you have a body cam on, even if you forget to take a picture, you can see it on a body cam. So one more reason why I strongly urge all enforcement officers to have the body cams and have it on anytime you interact with the public, so we can preserve things for later.
You said mock jury, but I think brings a certain connotation of what, when I heard that in the courtroom, and then what people at home may be hearing or reading is, oh, there was a mock jury, there was a mock trial, and you went through that whole process. But really, when you say mock jury, you're saying we impaneled a focus group and asked them limited questions and only showed them the video?
You are right. It wasn't a trial in the sense that we presented the whole case on both sides. We don't have a budget for that. But we wanted to find out how an ordinary, diverse panel of jury-eligible Milwaukee residents would view this the dash camera and the stills that we created for the dash camera. I might not have mentioned it. We created 10,200 still images. Every 30th of a second was a new image, and so we had all those reduced to still images so we could really look at them more closely. What we did is we explained the law of self-defense to them, because that's what this video and the still images were relevant to. And because it was a focus group, we were trying to draw all of them out. We just, when you have a mock jury and they go back and deliberate, 1 or 2 or 3 people can dominate the conversation and you never hear from the others. We wanted to hear from everybody. So we showed the video and we showed the still images as often as they wanted to see it. Tried to answer their questions as best we could with the evidence that we thought we could prove, and then listened to what they had to say about what they were seeing. So that was what we actually did.
And that was only 9 people.
It was 9 people. It was.
For people who look at this case and the outcome today and say, well, this is just another officer who got off the hook, claimed self-defense. What is your biggest takeaway from this investigation, and what do you say to critics?
You want to? I mean,
Yeah.
We've each got our own opinions about this. So.
We can only handle what case we were given, and if you compare it to other cases around the country, they're just vastly different. And so I think it's wrong to put all officer-involved shootings in the same bucket and say they're all the same. They're as varied as every other type of crime that we have. There are plenty of cases that I see around the country and think, I'm not sure that was the right result. But I also know there's a lot more to it than what I see on TV or read in the paper. We looked at this from every angle we could think of. We talked to as many people as we could find. We searched for any way we could justify a charge, and in the end, I think we came to our conclusion separately that this just isn't the case to make the point. If people believe officers are getting away with things, this isn't the case to make that point. This just isn't the case that we see as criminally chargeable. That doesn't mean that there aren't improvements that can be made. That doesn't mean that some of our suggestions aren't worthwhile. I think there should be improvements both in policing and how we investigate these types of crimes, and those are in our report. But this case is just this case. And hopefully, if anything can be taken from this that's good, some of our suggestions might get a little bit of headway, and they can look at things like body cameras, recording all statements, recording officer statements, having DCI investigate these instead of neighboring departments, having DOJ take these cases instead of neighboring DAs, AB 112, which looks at it from a completely different perspective. I think all those are suggestions that are at least worth talking about, and that's what I hope people can take away from this, if there's anything good that can come out of this.
So my takeaway is a little different because my perspective is different. I mean, I began with the bias that we were going to prosecute. I read the transcript, I looked at the exhibits, I read all the testimony, and like Judge Yamahiro, I thought, this is an injustice, and I wanted to find a way. So my mindset was, I have to be persuaded that we can't win this case, and so that was my mindset going in. And I remember my first impression when the first time I looked at the dash camera video, my heart sank, and I thought, this isn't what I gathered happened when I was reading the transcript. And I wondered what other people would think, because maybe it's just me. And that's why we showed it. I showed it to so many different people, including the focus group. And thanks for raising that point. It's really a focus group, not a mock trial. So that was my bias going in. It's a tragedy, you know. It may not have been a prosecutable crime, but it's a tragedy. Jay was asleep. I believe he was asleep in his car at 3:02 a.m. on the 23rd of June. 5.5 minutes later, he'd been shot 4 times and was dying. How do you get from that position to the position 5.5 minutes later? And there ought to be a way to get better outcomes than that, even if it can't be prosecuted criminally because of the movements that Jay made just prior to being shot. That's why we worked really hard to look for some of these other solutions that we've presented at the end of the report. It's a tragedy, and I'd like to see fewer and fewer of these tragedies. I'm sure everybody would.
After this whole investigation, do you have any burning questions that's still lingering in your head? Or if you could talk to Mensah, what would be your first 2 questions?
I'd like to know about the conversation that occurred. Now, we have his version of the conversation in the police report, but that would be, you know, why did you stop? What were you concerned about?
I think for me, the burning questions are just those. I wish we had a video of the entire encounter and a body cam of the entire encounter so we would know. In terms of what I would ask Mensah, I think we've asked those, and I think I know what his answers would be. And so I think we've already asked the questions.
But you're a prosecutor, so I mean, like, I can imagine me asking him some of the tough questions. So.
Yeah. So Isaiah, just before I call on you for a second, I wanted to make another point. Imagine yourself in Mensah's position. You're riding through a park. It's 3 o'clock in the morning, and you see an occupied vehicle, and you see somebody who's apparently asleep or unconscious. You probably are wondering, is something wrong with this person? Is he OD'd? Is he having a seizure? Is he having some kind of medical emergency? So you've got to make a decision. Do I go and check on the welfare of that occupant, or do I wait for backup squads to arrive? If the person needs Norcan and is ODing, the sooner you can get to him, the better. It's kind of a no-win situation, because if he waits and the person in the car dies because they needed medical attention, that's one bad outcome. If he goes and checks on his welfare, this ended up happening, which is also a bad outcome. It's almost a no-win situation. I'm sorry, Isaiah, I saw your hand up.
Yeah, it kind of builds off of what she just mentioned about lingering questions for you as prosecutors, but because the footage is mute, were there any, and because you weren't able to actually question Mensah himself, you have to go through that interface of these written questions. Are there any questions that you have about what commands he was actually giving Jay in those moments?
We know some of them. Without relying on the police report, we know he told him to put his hands up, because you can see on the video that he's got his hands up. So that we viewed that as corroboration for his statement that he told him to raise his hands and stay away from the gun. Beyond that, there's only one witness, and you know, we've presented what his story is in our report, but we've cautioned you that we didn't rely upon that in reaching our conclusion about self-defense.
Did you ever find Jay's missing phone?
There were 3.
Yeah.
One belonged to Alina De La Rosa, and the Tosa police have that. I went and I saw it myself. There were 2 other phones that belonged to Jay. One was an iPhone that was in his pocket, and the other was a Blue Brand phone that was on his seat. The family has told us that the MPD returned the iPhone back in September of 16. The MPD inventory records show that they returned the blue iPhone at the same time. We asked the family for both phones, and they couldn't find either, and they couldn't remember receiving the blue phone back. But with the blue phone, we have a download, so we have a copy of everything that was on the blue phone. So even though we haven't accounted for it physically, we have its contents. And we know the iPhone was returned to the family. That doesn't seem to be in question. And we know where the third phone is. So that's a long-winded answer to say I think so as best we can.
Judge Imanero talked about how the DA originally handled this case. You know, it was like 6 pages, but you guys kind of went thorough. You just want to speak broadly about why you thought it was important to kind of be thorough about this and have kind of like reports going through all these scenarios and different charges that could have been done.
The question is why we write the report as we did instead of.
Why you thought it was important to compared to what was done previous with the DA.
We knew we were coming at this after other people had already looked at it, and so we didn't want to just review their file and say we agree or disagree. So we tried to be as objective as we can and not rely on what they found, and review everything we could. Now, we didn't uncover a lot of new facts. This happened a while ago, and some things are lost forever. But we knew that the community needs to know either way, whatever we're doing. If we're not going to charge, why? We wanted to be able to explain that. We knew that there would be questions if we didn't charge, and we wanted people to understand why that is, and that we took this serious, and we wanted to give it a transparent look, an objective look, and a thorough look. And short of giving you everything we did word for word, we tried to give a thorough yet readable report to explain what we found, why we made the decision we did. And then I think both of us, as we went through it, decided, if nothing else, let's at least make some suggestions to whoever reads this going forward that, for what it's worth, might help. So we, I think, added the part at the end as we started noticing ourselves, it would be better had, this been reported. It would be better had, this been done different. And so let's see if we can improve the process, even if we're not going to charge.
Do you think anyone's going to take your recommendations?
Well, I think that's part of your job. We're trying to publicize some of these recommendations. Hopefully they will. To the earlier question about the earlier reports, I made it a point not to read those reports until I had thoroughly gone through the evidence, because I didn't want to be looking at the evidence to confirm what somebody had had previously concluded. I ultimately concluded that the DA's report was citing the wrong legal authority. They were citing Graham versus Connors, which is a constitutional use of force case involving civil damages. It's not a criminal case. It's not a homicide case under Wisconsin homicide law. I don't know why they did that, but I was perplexed. We spent some time talking to law professors about that. It's probably because the most extensive body of law has been created under 1983, the federal statute that embodies the protection of the 14th Amendment. So there's more case law talking about facts, but we're in Wisconsin, and it's our homicide law that was, it was our charge. So I didn't pay a whole lot of attention to those other reports. As Tim said, we wanted to be as thorough as we could. We wanted to show our work. If it's lacking, we want people to know that it's lacking. Hopefully, people will conclude that it was as thorough as we could be 6 years after the fact.
If the statute was worded differently, as it was previously, that allowed for this to move forward, for special prosecutors to be appointed, and that those words were shall instead of may, would you have issued criminal charges?
I wouldn't. If I, as a prosecutor, don't believe somebody's guilty of a crime, I've got no business representing the state of Wisconsin publicly accusing that person of a crime. I've got no business standing in front of a jury to say convict that person if I don't myself believe that I would convict them. I think it's on some level dishonest and if not per se unethical, at least immoral. I have no reason to charge people that I don't believe are guilty. It's that simple. So if a judge said you have to charge this person that you don't think is guilty of a crime, no, I wouldn't do that. I wouldn't take the appointment. I wouldn't do the job. That's just not. It'd be like telling an officer to arrest somebody that the officer knows didn't commit a crime. I would hope the officer would say, I'm not going to do something that I don't believe in. So for me, it's an easy call. If I don't believe somebody's guilty, I've got no reason bringing the weight of the state against them and publicly forcing them to answer charges and asking a jury to convict somebody that I don't think should be convicted.
We have a couple questions over here. Isaiah, go ahead.
Yeah. So points raised about the investigation itself, about the involvement of law enforcement officers, not only on the scene itself, but in the days after the fact, have canvassing the area for witnesses. Joseph Mensah was actually moved on basically desk duty to the detective bureau, while the Jay Anderson case was the investigation. He would have been in the same bureau or room per se as some of these officers who were going out looking for witnesses days after the fact. My question is, do you have concerns about the independence, the integrity of the system we have in Milwaukee, the Milwaukee area investigative team, and just how they decided, it's hard to even say they given their structure, but how the team decided to carry out the Anderson investigation?
I think I've got kind of two answers to that. I think it would be better if they didn't do it that way. I think it would be better if a state agency would do this, so there's more of a distance between local officers, because I do work with neighboring departments quite often, and so that is why one of our recommendations is I think it would be better for transparency and for trust in the system to have a statewide agency investigating these types of cases instead of local agencies. Having said that, I didn't see anything in the investigation I thought was covered up or a conspiracy or anything hidden. It's not unusual to have local agencies help the investigating agency do things like canvass a neighborhood. This isn't a case where I don't think there was any evidence lost by doing that or compromised by doing that. I understand some people question the integrity of that. And that's fair, but at the same time, I don't see that there was any evidence that was manipulated or hidden by those activities. The main evidence of this incident was the video, and that was preserved. The rest of it, it would be better if they hadn't done it, but I didn't see anything that I saw was dishonest or hidden. The Milwaukee investigators, I thought, did a pretty good job. They all were very cooperative with us and were very open with what they found, and I think they did the best job they could with what they had. So I didn't see anything improper in this investigation, but it would be better to avoid that question if it were done by a state agency.
So I don't disagree with what you've said. The Tosa Police Department, obviously we all agree they shouldn't have removed the gun before it was photographed. That was a blunder, and there's no sticking up for that. It shouldn't have been done. It was a mistake. It wasn't a Milwaukee PD mistake. It was done before anybody else arrived at the scene, other than Sawyers, Mills, and Lallier. The other part of your question relates to the things that the WPD did as part of the investigation in the aftermath of it. There are some things, I interviewed now retired Captain McClin, who is in charge of this investigation from the MPD's point of view. We also spoke with Professor Mike Scott, who was involved in drafting the statute that required independent agencies to do these kinds of investigations, because we wanted to get some background. And asking the WPD to do sort of ministerial things, like going to the elementary school and collecting all the videotape. Not a problem there. Asking them to go knock on doors in nearby apartment buildings to see if they could find anybody who saw anything or heard anything, with the idea being if they did, then the MPD would come in and do the interviews. Perfectly normal. In addition to that, WPD people did interview some folks that were in the medical ambulance, the vehicle that transported Jay to Freighted, and they interviewed some of those folks. It turns out at the end of the day, it doesn't matter. It wasn't relevant to our investigation, but Captain McClin said they probably went too far, because that's not what we would have asked them to do. We would have had our people doing those interviews. But I think if you check into it, I'm not positive, so double check me on this. I think this may have been the first officer-involved shooting in Tosa under the arrangement that was formalized where Milwaukee, where an agency outside of Tosa would do the investigation. It doesn't surprise me that there were a few hiccups in the process, but there was nothing that happened in terms of what the Tosa police did, other than removing the gun, that affected the integrity of the investigation.
Another example is a WPD officer attended the autopsy, which they wouldn't have to and probably didn't need to do it. But again, you talk to the medical examiner, that doesn't change the autopsy. She wasn't influenced by them. They didn't add anything or try to hide anything. We had photographs. So on the one hand, they were involved more than they should have been. On the other hand, they were probably learning a new process, and it didn't affect our conclusion.
We actually went to the medical examiner's office or contacted them and asked for a list of all of the people that attended officer-involved shooting autopsies, I don't know, over the past 10 years or something. It was a lengthy period of time because we wanted to see how common it was for a representative of the department that was being investigated to be present at the autopsy. And there were quite a number of instances in which the agency in the position of TOSA was actually had a representative present. But it didn't change anything, but you know, and it wasn't uncommon. Did I miss a question?
I guess one of my last questions would be for both of you, but particularly for the district attorney. Since you're a district attorney and you work very closely as a prosecutor with law enforcement, did you feel at any time that your involvement in this case would affect standing professionally with your colleagues?
I didn't. No, I don't work with anyone down here in the law enforcement world. I don't have any real connections to the southeastern corner of the state. I talked this over with a lot of law enforcement officers in my area and for help, and I didn't get any feeling one way or the other that they were either trying to pressure me one way or the other, or that if I charged them, they would be against me. I didn't feel any pressure like that.
Do you have the video? Would you play it for us?
The video?
That one?
I do have it. Do you really want to see it? I mean, it's still painful for me to watch. Let me do two things. So this is frame 514. That was the top frame that you saw before. So I'm going to show you the next 2 seconds. I'll show you the whole video if you want to see it. It's painful to watch. This is Jay's right hand. This is Jay's head. The headrest is behind it, and you will see that what he does is he leans that direction, and his hand drops. And this is the 2 seconds immediately before Mensah begins firing. And you see that after he was first hit, that's when he straightened up, and so there was some testimony at the trial that he was sitting straight up when he was shot. Well, you could see he wasn't sitting straight up when he was shot, but after his shot, he became straight up. And that's a difference that's really important if you read their expert testimony at the hearing last year, because you would come away with the impression that he was sitting straight up and he was fully compliant and just got shot straight through the head. And you can see that he was not in a straight up position and his hand had dropped. So those are the 60, a little more than 60 still frames. If you want to see the whole video. And you will hear the sound go on after the shooting is over when he pushes the button and activates the dash cam. So this actually goes on for about 2 hours. I listened to all 2 hours of it. Mensah doesn't approach the car until Mills and Sawyers arrive, and they approach the car first. So he doesn't go near the car again until Mills and Sawyers have removed Jay's body from the car.
One quick question. Can you just explain the reasoning behind when you wanted to speak with the officers? I believe it was 3 or 4 of them total, and granting them immunity. Can you just explain the reason for that?
Yeah, we're in a position where, as I said before, nobody has talked to us at all. So nobody's under any requirements to speak with us. So we ask people voluntarily to come talk with us. I think they contacted a union attorney who said, for abundance of caution, we want immunity for anything that they say. From our perspective, if that's what we have to do to get them to talk, that's fine. As special prosecutors, we have no authority to charge them anyways with anything. And if they did anything, a statute of limitations probably ran anyways. So in the end, it was kind of a no-brainer for us. If that's what we have to do to get you to talk, fine. There really wasn't anything for us to, be worried about or that we could do anything about anyways. So that was our thinking.
So, anything gleaned from those conversations?
Well, we talked to most of the WPD officers that were on the scene. In large part, we went over what they had said originally, and it was mostly the same, with the exception of 2 of the officers described where the gun was, where Jay's gun was in the car. That was not in the original reports. So that was new information that we didn't put a lot of stock in because it's a little too late to be adding things like that. Other than that, there wasn't anything new that came out of those.
But that did lead to our recommendation that these interviews be conducted and recorded when they're conducted originally, because we found that their memories 5.5 years later were faulty. One of them told us that he asked the gun to be removed because he thought that Jay was still breathing and what represented a threat. And I went back and I listened to the dash camera video, and you can hear that officer saying he's not breathing. And then a couple of seconds later asking Mills to remove the gun. So it's clear that he didn't think he was breathing, but after 6 years, he had a memory that he moved the gun because he thought he was still breathing. The other piece of it was, telling us that they have vivid memories of exactly where the gun was located on the front seat and where it was pointed and where Jay's hand was in relationship to the handle of the gun. None of that's in the police report. We talked to the MPD investigators and said those are the kinds of questions we would have asked them. That's what we were trying to find out, because the gun had been removed. The WPD officers that we interviewed, we gave them immunity only for the things they told us. If they didn't tell us something in the interview, they had no immunity for it. And so it gave them an incentive to be more fulsome with us. when they told us about the location of the gun, we said, why wasn't it in the report? And their response was, well, nobody asked. And we went back to the officers that did the interviewing, and their supervisor said, of course we would have asked. But how can you prove it if the interviews were never recorded? And that's one of the criticisms you'll find in our report. Where, that's.
If Jay wasn't breathing and didn't have a pulse, how can the officers argue that they were moving from the car because he could have been threatened?
Exactly. I think it's something that happened on the spur of the moment. One officer saw this gun. It's a pretty scary looking gun sitting there on the seat, and just said, move it, without really thinking about the ramifications of it. I talked to Captain McClin, who's, as I said, now retired, but who led the investigation. He reinforced in the strongest terms that he didn't think it was intentional, that there was any ill intent. He just thought it was a spur of the moment decision. That was a long decision. Have we exhausted you all? When you get a chance to read the report, if you have other questions, I'm happy to have you follow up and pose them. As I said,
One very last question. A lot of these families who have experienced police violence in the city report that they have been, while the investigation is going on, that they feel being monitored by police.
They feel what?
A lot of the families in the city who have had loved ones lost, killed by police while the investigation is going on, feel that they have been monitored by police while the investigation is going on.
Monitored by
Did you see anything in the investigation or in reports or anything that would indicate that there was undue attention on Jay's family and not the actual shooting itself?
No, but we weren't looking at that, and so it could have happened, and we wouldn't know about it. We met with them last night at my house. When we met originally, it was out at their house, and we were asked to notify, to give notice to the WPD so they could have officers standing by at their house. And I said, I don't want officers around. There's no need for officers. So I didn't mention this to the Andersons, but I guess we had it at our house. But the short answer to your question is we don't have any reason to believe it's true or untrue.
All right. Thank you so much.
You're welcome.